to whether we oppose or not control of the body. Principally, what the Honor is being called upon is to give a continuation extension of 21 days for the investigation. We submit to the Honor that the position of my good friend Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that you will need 21 days to complete the remainder of the 51% of the investigations. Why am I saying this? The frustration of my good colleagues that Your Honor be minded of the provisions of Section 123 of the Criminal Procedure Code, read in the Article 49(1)H, as well as G of the Constitution of Kenya in Mutembei, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with white powers, to make such a determined decision on bail bond with grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as it's been trained, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence as said is placed before you that the respondent is likely to interfere with any witness or investigation as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety. And we would only ask if the police saying that they are able to secure and safeguard the safety and interest of its citizens. In the threshold of that, Your Honor, we would plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators by way of affidavit that he is likely to become uncooperative moving on forward. And should in both lean as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, and that if they are limited, it would not in any way prejudice investigations, as nothing will bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with the Honor that you admit the respondent to bail bond pending this investigation, in the event of such misalignment, they're going to be considerate to reduce the number of days that the applicant seeks to hold the responsibility. Benign is submitted.
Okay. Your Honor, I was thinking that the colleague chapter was very specific. But let me start with it. Whatever you want to add, you can add. But Your Honor? Yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent. Please grant bail. And I'll be requesting the court very humbly. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and Article 49(1)H, they have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Does it become absolute once they fail? I'm saying they fail at least miserably. Am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyamo case, the court has indicated what is supposed to be a compelling reason. Paragraph number 23. What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the realm of Justice Republic. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once you have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they want to have access to these forms. What they did not tell you is that he gave them the password and they're keeping quiet. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the way. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't take 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important. So what they have there is a shell. And that's the reason why they can't pick it. And that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. And they're telling you they are going to interfere with the investigations. But in his affidavit and what he has said here on oath is that, in fact, I've given the password. It is just they are telling you. So you don't have to take it. But the issue is not about
the scene of the first one.
You can't testify. You just
Requires a lot of things.
no. Your participation. What are you? Now they're telling you about witnesses. They are not telling you in the affidavit which witnesses, but they are telling you something else that is imaginary. That they are yet to get some other witnesses who they are going to take. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement and inquired. When the DCI director himself spoke and made some wild allegation in Parliament, the OCS woke up by himself and took himself to the Gigiri police station, headquarters CID, and asked, do you need anything from me? Look at this kind of person we are talking about. Do you need anything from me? Okay. Then they arrested him. Why would you deny him bail, Your Honor, when such a person has exhibited a person who is capable to cooperate and even volunteers before they get those Subarus to go and pick him? He volunteers. So today, we are talking of a person who knows the law and respects it. Those are the grounds that they had for you today, Your Honor. So what else remains? Now let us go back to that issue of the litigation. Then have they convinced you, Your Honor? And I'm saying they have not. And that is why I will agree with my learned colleague that if you gave him a cash bill of 7K, that is fine. In fact, for me, I'd say free bond. Because at the time he was going to those officers, he was okay. There was no money, there was no cash bill, but he went. That shows a person willing to come to court. They quote Article 19, they quote all those articles in the law. But you see, Your Honor, today, let us agree. Why do we have these fundamental rights? It is so that we can protect this kind of person from this kind of people. The police. That is why we have these fundamental rights. And Article 19 is quite clear, and it's my favorite, that these fundamental rights, who do they belong to, Your Honor? They belong to an individual and not the state. Not the state. Once they know that those fundamental rights exist, they come to Article 20, which is very clear and says it binds all state organs, including the court, including the prosecution, and including the officers, the police officers. That includes also IPOC. If it includes them, today they come with an affidavit and tell you, denying bond on very flimsy grounds. Did they read Article 21? I'm certain that they ignored it because Mr. Whitty, my friend here, would have told them. And I don't know why he's not telling them. Article 21 is clear that when these fundamental rights are known to exist, all these arms that I have mentioned, what are they supposed to do, Your Honor? They must start by wanting to grant this fundamental right. Article 20, sub-article B. Might start by wanting to grant to ensure that this person enjoys the fundamental right. But they still give you this affidavit. So what do we do, Your Honor? Article 22 is clear. Once we have noted that they are in a position where they want to prevent an enjoyment of these fundamental rights, we come under Article 23 and Article 165. Very clear article. So that the court, once it has noted this kind of, can I call it, bad faith application, will be able to see. Let me qualify it to say, why does it come under bad faith? You have an IO who has come to court today. What does the IO do? Refuses to answer questions. Yes, he will not answer that. He will not say anything. He doesn't know anything. He doesn't even know who his boss is. And he doesn't know whether he attended a press conference. Now, things that are in public domain, and we know them by ourselves.